Thank you, Mr. Chair. Welcome, Mr. Minister. You certainly know that the right to vote is a very important right. It is, in fact, the right at the basis of citizenship in a country. When you're a citizen of a country, you have the right to vote. It is an essential condition, and the law in many provinces and in fact in many democratic countries establish some criteria to have that right to vote. Not only do you have to be a citizen, you have of course to be 18 years old and so on. You have to be resident of a province for a certain period of time, the same for Canada and so on. So I think that the court accepts generally the principle that there are limits, reasonable limits to exercise the right to vote. That is to participate in the democratic process of choosing the government and expressing political views. And you certainly, you have probably read, I would not say certainly, maybe you have read the decision of Justice Mongeon in Quebec last Thursday in the context of the Quebec election, whereby a student inscribed at McGill's wanted to vote and create a lot of fuss during the campaign. And Justice Mongeon reestablished the principle, and I think it's very recent, 48 hours ago. I think the objective of establishing the identity is not dispute. As you state, to establish the identity through a series of various documentation, you list 39, is well accepted all over the world. In democratic country, I would say. The problem is that you are removing one way to identify, to prove the identity, which is the vouching. That's the problem. The problem is, the dispute is not about establishing the identity. The problem is that you are removing from the Act at 143 the opportunity for somebody to be vouched. And this committee, and personally, and many members around this table are concerned when a bill arrives here with the constitutionality of the bill. It is the first test, moreover, that we apply to a bill. And I have to say to you that in the last 8 years, we got many bills where question was asked for by the minister testifying, Minister of Justice or other minister, is it charter proof? And we just, oh yeah, Minister of Justice has assured us that it's proof. And we know what happened with the Supreme Court, the most recent decision being the Nadon decision. We had the minister here testifying that, oh yeah, we have checked, we have even more than checked, we have two former justices of the Supreme Court testifying, and Peter Hogg, and you know, the largest authority. And we maintain our doubt about the constitutionality, and the court confirmed the non-constitutionality of the bill. In this case, the problem is that if we apply the Oak test of the Supreme Court to the fact that you remove the vouching, my opinion, Mr. Minister, is that it is unconstitutional. The Oak test states three principles. The first principle is the objective of the legislation. The second is there a proportionality between the means used to serve the objective? And in the case for you to serve the objective, claiming that there is irregularities and there might be even fraud, there is fraud even with the identity, by the way. Fraud will always exist. I don't think we try to limit the fraud, but fraud will exist. I think that you failed the test because instead of strengthening the vouching, you decide to wipe it out. You could decide to strengthen the vouching. For instance, to ask for 2 persons to vouch. Or you can ask more information about the person vouching. For instance, to sworn the person. To have the person have 2 pieces of identity. To not to be able to vouch for more than 1 person. You know, there is a way to frame the vouching system in a way to limit the irregularities or the fraud. But what you have decided is, okay, we delete it. That's why I think there is a problem in your approach to the vouching. Because the Supreme Court is, in the Figueroa case, I will quote you one case, you quote one, I could quote you one. 203 Figueroa, which is the leading decision, by the way, with the right to vote. The court has said very clearly that in relation to Section 3 of the Charter, we have to adopt a broad and purposive approach. The purpose of Section 3 is effective representation. Section 3 should be understood with reference to the right of each citizen to play a meaningful role in the electoral process rather than the election of a particular form of government. So it's quite clear that it's a right to participate.
And vote.
Yeah.
Or question, I mean.
No, I'm not pleading in the court, but it's a professional deformation. But that's the problem I have with your reasoning, and I'm sure that you all know this, and I admire your firm decision. But we all know that this section will go to the court. I mean, I've read too many lawyers and too many constitutional experts, even what the former Auditor General of Canada said in relation to that this provision of the bill, I would not say your bill, of the bill, will be challenged in court, and I am not at all certain that it will succeed in the court because it's not proportionate with the objective that you aim to serve by removing it. That's my reasoning in relation to that. What do you agree or not?
I don't agree.
That's the question.
I don't agree.
So
no,
see you in court then.
Okay. But I mean, listen, you mentioned safeguards, Senator. The problem with the last election is that not only were these safeguards violated 50,735 times, since then, the Elections Canada has come out and said they're really not important. And so you can add as many safeguards as you want, but if they're not honored or administered, then they don't have any value whatsoever. As for the issue of the constitutional right to vote, I would encourage you to consider the unseen violation of someone's constitutional voting rights that results from an ineligible vote. If you legitimately and honestly vote for candidate A, and someone else fraudulently votes for candidate B, your vote has been mathematically canceled out. You have lost your constitutional voting weight because your ballot does not mean anything. It is canceled out, literally, by an ineligible one. So the objective of ensuring the eligibility of the voter is just as important as ensuring that everyone has the right to cast a ballot. We believe that with 39 different forms of ID, that can be achieved.
Thank you, Chair. I find it strange that I've only been on this committee for a few months, but every piece of legislation that we have had brought in by our government, the first argument by opposition and media is that it's not constitutional. And so let's battle it on that ground first and foremost. And I would say in most cases, if not all of them, the government has won the day there as well. Another comment I do want to make before I ask my question is that I think making it more difficult is not taking away the democratic right of somebody. We are tightening up some rules. I have been involved in election campaigning for somewhere between 40 and 45 years, and I have seen progressively the voter fraud, I believe, and certainly in the last Manitoba election, we had a number of cases that we proved that there was voter fraud, is getting more and more rampant. So I applaud you, Minister, first of all, for bringing in what I think is a very, very good bill that will certainly not disenfranchise people, but indeed help those people that are out there legitimately and honestly voting for candidate A or candidate B. My question, Minister, is very simple. Do you have to show that you're a Canadian citizen in order to vote?
It is a requirement to be a Canadian citizen to cast a ballot. We do not have a national citizenship ID card that can prove that. Therefore, the method of demonstrating it is, one, if you can be on the voters list, and two, if you're not, you can take an oath that includes citizenship as part of it. And there is a fine of $50,000, a proposed fine in the Fair Elections Act of, I think, $50,000 for anyone who lies under oath as to their citizenship. And this is not a perfect safeguard, but it is the best one we can find given the system of citizen identification that exists or better, to put it better, doesn't exist in this country.
Thank you, Chair.
Can I comment on one other aspect of the Senator's comments?
Yes.
We're here, we are a part of the legislative branch of government here. We are not the judicial branch of government. We draft legislation that we think is good public policy. It is not the role of the legislature to rule for the judiciary. And I appreciate their opinions as to constitutionality. I firmly believe this bill is constitutional, and I am prepared to defend that anywhere. But that decision, with the senator across, Mr. Royal says that he would, would like to potentially challenge that. That is his right, but the judiciary makes those decisions, not the legislatures.
All right, thank you, Senator McIntyre.
Thank you, Chair. Thank you, Minister, for your presentation. I just want to make sure that I understand the reasoning behind this legislation. C-23 proposes amendments to the Canada Elections Act and various statutes. As I understand, the amendments are in response to concerns raised by the Chief Electoral Officer and supported by the House of Commons Committee. The amendments are also in response to reports prepared by Elections Canada. On top of that, some of the amendments in the bill also form part of Bill C-21 and C-40, and as you know, both died on the order paper. Finally, the number of amendments are mainly government initiatives. Am I correct in this analysis? Is this the reasoning behind C-23? To address concerns by both the Chief Electoral Officer and Elections Canada?
I think that the bill is not written just to address the concerns of Elections Canada. It deals...
but it also ties in to other bills which had died on the order paper, C-21 and C-40, as I understand.
Well, for example, the Political Loans Accountability Act
Yes, yes.
responded to a loophole that emerged in the aftermath of the donation limits that both Liberal and Conservative governments instituted. We discovered that the series of leadership candidates were using loans, unpaid loans, as a means to get around donation limits. And the Elections Canada did not hold any investigation as to whether or not that was a deliberate attempt to avoid the donation limits, which would be an offense under the Act. So we're, for example, closing that massive loophole. That is just one of many examples of the catalyst for the Fair Elections Act.
Okay.
But, while we do accept about 38 recommendations from the Chief Electoral Officer, the bill was not designed to necessarily respond exclusively to his concerns. Well, we've taken those into account. This is a democracy, and every Canadian has a say.
Okay. Thank you, Minister.
Senator Dagenet.